All rise. The Court of Appeal in for the 5th District of the State of Florida is now in session. The Honorable Richard B. Orfinger, Judge, presiding. All persons having business before the court draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning and welcome to an oral argument session of the 5th District Court of Appeal. As the Marshal indicated, I'm Judge Orfinger, and I'm joined on the panel today by Judge Rand Wallace on my right and Judge James Edwards on my left. We have two civil cases today, Howell versus Care One and AMDD Investments versus Prestwick Partners. The parties will have 20 minutes per side. If the appellant wants to reserve, the clock is set at 5 minutes, but if you want something other than that, let me know, and I'll be happy to set the clock so that when it flashes orange, you're into your rebuttal time. If you have a cell phone or any other device that's going to make noise, we would appreciate it if you would silence it so that we don't interrupt the parties during their arguments. And with that, we'll go ahead and call the first case, Norman Scott, D.O. versus Care One Primary. Good morning.
5 minutes for rebuttal will be sufficient. 5 minutes for rebuttal.
Yes, ma'am.
Will be sufficient. Thank you. May it please the court, my name is Angela Covington with Carey O'Malley, Whitaker, and Mueller. I represent the appellant, Dr. Scott Howell, in this case.
Could you pull the mic just a little bit closer? Thank you.
Is that good?
Yes.
This case is on appeal from summary final judgment, which is entered in favor of Care One and against Dr. Howell. We've raised several issues in the briefs, but there are two main issues on appeal I wish to focus and highlight today. First, because the order on Care One's motion for summary judgment did not adjudicate all issues in the case, it was inappropriate for the trial court to enter final judgment thereupon. And second, it is Dr. Howell's assertion that the trial court abused its discretion by denying Dr. Howell's motion for leave to file his second amended complaint and add account for quantum merit.
Do you agree then that the summary judgment was properly entered?
I do not agree that the summary judgment order was properly entered. In the brief, there are various issues that are raised. However, I do understand that it is within the trial court's discretion to decide whether to consider affidavits and to consider deposition testimony. And in our particular case, the trial court chose not to do that. And the findings in the summary judgment order, which are that Dr. Howell was not entitled to the remaining wages, so future wages under the contract, but did not reach the past due wages, which he'd earned, was a foreseeable and reasonable finding. That is why we're focusing on the two main issues I've mentioned, and that is that the final judgment was improperly entered. I'd like to give you some brief background facts, but if you don't need them, I can move on.
We're familiar with the facts.
Very well.
Let me ask you this. Part of your argument is that the employer here was aware of the prior conviction when they entered into the contract, and as a result, that shouldn't be a disqualifying event. But when I look at the contract, and in particular paragraph 14.2, which is the integration clause, it says, among other things, no oral statements or prior written material not specifically incorporated herein is of any force or effect. Each is relying solely on the representations or agreements, whether written or oral, not expressly incorporated herein or superseded, and no changes, etc. So basically it's an integration clause. It says if it isn't in writing, it doesn't count. And so even if they were aware of it, and let's assume for the sake of my question that they were, how does that then play into the requirement that he be eligible to bill Medicaid that's contained in the agreement?
We do raise that argument, and I see the point that you're driving at. There is an integration clause, and my position on Care One's knowledge about Dr. Howell's history has more to do with the fact that they chose to employ Dr. Howell without completing all of the background that they would typically do with an employee. You know, part of the argument here is that as between the employer and the employee, when you get 5 months into a contract, the onus, if something does turn up, and all of the parties had knowledge prior to the contract being entered into, the onus should be on the employer to protect itself and run those searches and backgrounds prior to letting someone work in its clinic. And so that's where the prior knowledge plays into my argument in the case and my interpretation of the case. I think the most important thing about what Care One knew is that Dr. Howell had, served his punishment for what happened in 2001, and that the letter from ACA was an error. And it was told him, and it's in the deposition testimony, or it's in the affidavit from Dr. Howell, that the fact that he got that letter from ACA was not going to be a huge issue as long as he got it cleared up quickly. And their knowledge prior to and during the term of the contract with regard to what had happened in 2001 is important as it relates to that point. I hope I've answered the question. I will move on to the argument with regard to the summary judgment order. In the order, let me just get to where I was one moment. Okay, so at the time the motion for summary judgment was filed, the amended complaint was one count for breach of contract seeking two types of damages. The first was the past due wages, which you're familiar with, and the second was the future wages. In the motion for summary judgment, Care One relied on section 408.809 and chapter 435 of the Florida statutes to argue that upon receiving the ACA letter, Care One was absolved of any liability to Dr. Howell whatsoever, whether it was for past due wages, future wages. That seemed to be their argument. And
so in effect, Care One was seeking a rescission of the contract? Is that
not in its
their cause of action, or their response?
In their affirmative defenses to Dr. Howell's amended complaint, they were not seeking a rescission. They raised defenses of mutual mistake. I believe fraud in the inducement might have been one, and the issue of rescission was only raised in their counterclaim. And the motion.
The effect of mutual mistake would be no contract, correct?
That's correct, but there were no facts in the record filed by Care One in support of its motion to indicate to anyone that they were seeking summary judgment on the counterclaim or for rescission, or to support a mutual mistake defense. The motion for summary judgment was filed without affidavits. It was filed solely, based upon the letter from ACA and some records from Dr. Howell's previous case.
And your affidavits were late, is that correct?
Our affidavits were filed to explain that process. When the motion for summary judgment was filed, it was our opinion that the facts raised in the motion were true, the facts being the ACA letter had been received, and the statute said what the statute said, and Dr. Howell had the past that Dr. Howell had. And the argument was anticipated to be a legal one related to whether Dr. Howell would be entitled to receive the remaining wages and or past due wages. In hindsight, an affidavit should have been filed in advance, but looking at the argument at the time and based on how the pleadings were constructed, those were the issues as we saw them.
And the rules clearly set out when the affidavit should be filed and when it's obviously de facto when it's late, correct?
That's correct. And after the summary judgment hearing and based on the summary judgment order, we would not have filed a late affidavit. The only reason that affidavit was filed is because after the summary judgment order was entered, counsel for Care 1 filed a motion for entry of a final judgment. And the motion for entry of the final judgment made statements that were not consistent with the findings of the summary judgment order. And at that time, we felt that the pleadings appeared to be running away with things, and we needed to get something in the record to demonstrate the finer points of our case, which are the points in the affidavits and the points that were made in the deposition testimony. The summary judgment order says that Dr. Howell was not able to, based on the ACA letter, work without restrictions. That without restriction language is from the IPA. And he says, I'm granting summary judgment, but I'm not reaching the issue of the past due wages. So a reasonable interpretation based on the pleadings to date was that he was granting their motion for summary judgment as to the remaining wages, but not as to the past due wages. And then the motion for entry of final judgment filed by opposing counsel said, based on the court's finding in its summary judgment order that the contract was void, final judgment should be entered. Well, the summary judgment order doesn't say anywhere that the IPA is void. It merely states that summary judgment is granted because Dr. Howell was unable to work without restriction. And that issue, the fact that the ACA letter caused a breach of Dr. Howell's contract because he was unable to work without restriction, is not something that we believe was a retroactive issue. At the time the IPA was signed, there were parts of the contract that Dr. Howell was able to and did perform, and he's entitled to be paid for those services.
Well, but do you agree or disagree that Section 408-809, subsection 9, bars any action, any cause of action for damages against an employer if the termination is because of disqualification?
I disagree that that statute means that if an employer terminates an employee, then the employer does not have to pay for services rendered to date. I think it would have...
On notice of a disqualifying offense, no cause of action for damages lies against the employer. How do you interpret that differently?
I read the section as a whole to say that the employee is not entitled to any kind of unemployment assistance upon termination. So I read that to say that upon termination, that employer has no further liability, no liability and no cause of action upon termination. It would have been very simple for the legislature to state in that section or anywhere else in the statute that any contracts that purport to employ someone who subsequently receives some sort of notice or notice of a disqualifying offense, that contract is void, and it would be easy to say they're not entitled to collect any wages earned to date, but the statute doesn't say that. And in this situation where it's, like I said before, where the onus should lie is with the employer to have those issues resolved prior to letting someone work for them.
I understand the concept that it seems unfair that he could have worked and performed services and the clinic billed for, and I don't know if they received money, but they certainly billed for the services he performed. But there's kind of a similar setup with building contractors. If you're not a licensed contractor, you cannot enforce your contract. You can do $1 million worth of work and provide materials, and your contract is unenforceable. It seems like that's, the language is slightly different from the unlicensed contractor to this, but no cause of action for damages. If all they wanted to say was no unemployment, they could have stopped really after the first phrase there.
Sure. I think we have to look at, there are a few things that we could look at, but one of the, I think, most telling is the termination letter from Care 1 to Dr. Howell, which states that he would be paid through the date of his termination and also offers to allow him to continue working his emergency shifts. Clearly, and this is part of our argument about Care 1 not meeting or, meeting the burden of proof on summary judgment, there's no record evidence. And the only record evidence, even if it was late filed, is that Dr. Howell was applying to become a Medicaid provider for Care 1. The contract is clearly there are other duties he was going to have other than providing Medicaid services. And there is testimony, and this goes more to, even if the affidavit was late and even if the deposition testimony couldn't be considered on summary judgment, it is in the record, and we have a motion for leave to file, motion for leave to amend, you know, and those items can be considered in the motion for leave to amend. And there is evidence that Care One collected money from insurance carriers and patients for services that Dr. Howell provided. And you can't say, well, this contract is void and against public policy and he's not entitled to be paid for the services he provided. But yes, Care One did, you know, was paid for the services that he provided. I mean, it's just a double-edged sword and it shouldn't be permitted.
I don't disagree with the equity, if there is such a term here when you're interpreting the statute, but it just seems to me the statute covers it, and I think that perhaps is why the trial judge entered final judgment after summary judgment.
Well, if that were the case, I think we'd have a different looking final judgment. I mean, he doesn't say, based on that section, there's no liability for Care One. He says that the contract is void. And that's contrary to what he said in his summary judgment order, that his findings did not reach the past due wages. And I'm not sure what happened between the entry of the summary judgment order and the final judgment, but the final judgment clearly says that he made a finding in his summary judgment order he did not make. And that's not consistent with a ruling pursuant to 8099. I agree with you, the language is tough, but I think when you read the whole section together, it's a reasonable interpretation that no cause of action based on the termination. You know, I do think that's a reasonable interpretation. I'll go ahead and touch on this our last main point, which is that the trial court erred by denying Dr. Howell's motion for leave to file his second amended complaint. By entering the final judgment and the summary judgment order, stating he wasn't reaching past due wages, but disallowing Dr. Howell to file a motion based on a quantum merit claim for the past due wages. He has created a result that is disfavored by Florida law. Since I'm running a little bit low on time, I'll just jump to Care One's arguments in response to Dr. Howell's argument that he should have been allowed to amend his complaint. And the first is that amendment would have been futile, and this goes to the point of 408.8099. We disagree that the amendment would be futile. We, like we've talked about, interpret that statute differently. And further, if the court looks to the deposition testimony and Dr. Howell's affidavit, the only evidence in the record suggests that he was not terminated because of this notice from ACA. It indicates that he was terminated because he was not willing to renegotiate his contract at a time where Care One was having a cash flow problem. And that affidavit and those transcripts can be considered in deciding whether the amendment is futile, even if they can't be considered in connection with the motion for summary judgment. That takes that 408.8099 out of the picture because it's not the reason he was terminated, and they shouldn't be allowed to rely on that statute. Care One also argues that Dr. Howell should not be entitled to bring a quantum merit claim because the court declared that the IPA was void ab initio. Again, we have the problem with the final judgment versus the summary judgment order on this point, but also Care One relies on a case, TTSI Irrevocable Trust versus ReliaStar Life Insurance, which finds that where the contract was void, no party was able to receive relief from the court. The court would leave the parties where they found them. But that's a case where one party was found to have acted fraudulently at the time the contract was entered into. I believe that our case is more akin to something like Webb versus Hillsborough County, a Florida Supreme Court case, in which even though a contract was found to be void, the contractor was entitled to his damages under quantum merit, where quantum merit for the value of the work performed, where the county that it had worked for was an enjoyment of the fruits of the contractor's expenditures. As here, Care One has enjoyed the fruits of Dr. Howell's services for those 5 months he worked, And unless you have any other questions, I will have a seat.
Thank you
Thank
so
you.
much. Give me just a minute here to get the clock set. All right, sir.
My name is Cliff Taylor. I'm representing Care One this morning. This is a matter of first impression on Florida Statute 408-8099, but there's an interplay between the disqualification statute with 435.06, which is a screening process too. The legislature has spoken in both the screening process as well as the disqualification process that no cause of action should be considered upon terminating an employee that's disqualified. And there was a number of motions filed after the order was filed. The court, the trial judge, said that he considered all of them. One of those was the response to plaintiff's motion for clarification and to amend complaint, found at the record at 185. And I think this is important. Before the paragraph about no cause of action, this paragraph 3 says this: any employee who refuses to cooperate in such screening or refuses to timely submit the information necessary to complete the screening, including fingerprints if required, must be disqualified for employment in such position, and if employed, must be dismissed. So the legislature has spoken twice. There's no cause of action. But let's move on to what was in front of
Is there any evidence that he refused to cooperate?
Well, I don't think there's evidence in the record, although it took a long time.
That's all we can look at is what...
That's all you can look at. But what did come back from ACA, even though it had a problem with said that you're disqualified for fraud and kickbacks. The fraud he did not plead to, but the kickbacks was part. That alone in itself was enough to be disqualified.
Under subsection 9, must the employee, in this case Dr. Howell, be terminated because of receiving the ACA letter?
Yes, I believe so. I think it creates a liability to Care One to keep retained an employee that is disqualified.
And what evidence in the record was there that that is why Care One terminated him? I understand the temporal relationship, but in terms of we got the letter, that's why you're fired.
I believe that was the termination letter that's in the record. It's because we got this ACA letter.
Opposing counsel mentioned a letter from Care One saying you'll be paid to date. Is that accurate? Was there some kind of a termination letter or other communication that said that he would be paid to date?
Yes, I think in that termination letter, I think there were some offers to further negotiate. Can we do something different? Because part of the business plan in the contract was for the doctor to be the medical director to provide services in Medicare and Medicaid. So my client really didn't want to lose him totally. If they could have negotiated something else, that was up for discussion. But that was part of the termination letter, and it was discussed.
Is that a waiver of your right to rely on the statute if you say that we'll pay you to date? We're going to terminate you, but we'll pay you to date. Is that a waiver of that provision in the statute? Or an estoppel that prevents you from relying on that provision in the statute that says that there's no cause of action?
Well, what is in the record, Your Honor, is that there were payments to Dr. Howell. It wasn't that he worked for 5 months for free. He was getting paid.
No, I understand. There's a dispute apparently over, what the difference is, that he wasn't paid per the contract. And so, whether... I mean, obviously, if he wasn't, my question really goes to, if he wasn't paid per the contract, is the letter, the termination letter that says we'll pay you to date, work as a waiver or an estoppel to prevent you from relying on that provision in the statute?
I don't think the legislature has provided a waiver defense here. Under both the screening process and the disqualification, it is a must. the employee must be terminated. Moving over to what was in front of the judge on consideration to amend the complaint, what was chosen was a quantum merit theory. And counsel has cited in her reply brief 2 older cases, the Webb versus Hillsborough and Robinson versus Short, a 35 and 1962 case. Those cases stand for the proposition that a quantum merit or an implied contract could be created because there are technical difficulties in enforcing the contract. This is not the case here. This is not a technical difficulty. This is a public policy issue that the legislature has spoken on. Dr. Howell was disqualified for a felony conviction and not getting an exemption from ACA. That's entirely different from a contractor that did the work and for technical reasons under a bond was not, he was allowed to recover. And versus the Robinson case, which was a bid, was too vague to be enforced. But he did some quantum merit. They still implied the contract to get the relief. There's no other cases in this area to provide for that type of relief. And this is an entirely different situation. So what was in front of the court was a motion to amend to include a quantum merit theory. And I think the legislature, it would be contrary to the legislature's intent on the public policy that they've stated that that such an employee should not have a cause of action and should be terminated.
Were there any restrictions on his medical license as such? And that's, I'm referring to 3F in the IPA.
No, there were not any other restrictions. The only restriction really came from ACA on the Medicaid area.
Right, okay. How did the record explain the trial judge going from, I'm not dealing with the past due wages, to granting final judgment on that?
Well, there were various motions and responses to those motions, and we dealt with it by looking at the screening process too, where the legislature said that an employee must be dismissed immediately, and I think that's how the court dealt with it. If there's any other questions,
All right, sir. Thank you.
I'll rest. Thank you.
Go ahead. You just asked a question about how the record reflects the path from the summary judgment order to the final judgment. And counsel referenced some motions that were filed in which the screening process in the statutes was argued. I would respectfully submit that if the court was going to go beyond the 4 corners of the motion for summary judgment, in which I don't believe the screening process was raised, the court should have also considered the motion for reconsideration and the affidavit and the deposition transcripts to look at the whole picture and see that this case is more than the ACA letter being sent. This case was, Care One was unhappy with the deal it had negotiated, and Dr. Howell refused to renegotiate until he was paid in full for services provided to date. And again, if you want to take a look in the record at the termination letter that was sent by Care One to Dr. Howell, it does state that he would be paid to date, and it also states that if he wants to continue working, he'll be paid a certain fee. Clearly, there were other services being provided beyond those that may have been, but that he may have been disqualified from providing in that IPA. And the final judgment, which states that the trial court had found in the summary judgment order that the contract was void, is untrue. There's no basis for that statement in the final judgment, and Dr. Howell should have been given an opportunity to amend his complaint and state a cause of action for quantum merit. If there are no other questions?
Thank you so much.
Thank you, Your Honors.